welcome all to this second panel, and thank you for joining us. As Koen mentioned, my name is Stephan Sottiaux. I'm teaching constitutional law and human rights law at the Leuven faculty. The topic of this second panel needs no introduction. The debate about the proper relationship between the European Convention and domestic fundamental rights law is as old as the Convention itself. In the course of its existence, the Convention institutions have developed a set of tools to negotiate between uniformity and diversity, between supranational and domestic fundamental rights protection. We can think of the safeguard for existing human rights principle in Article 53 of the Convention, the fourth instance doctrine, the margin of appreciation, procedure, rationality, and so on. And by and large, these concepts were successful in avoiding open conflicts between the Strasbourg court on the one hand and domestic constitutional courts and courts in general on the other hand. Although there are of course notable exceptions, such as the von Hanover case. So, although the topic is a classic one, new questions keep on popping up. So it is really a great pleasure to welcome three distinguished speakers who will look not only at the past achievements, but will also tackle new challenges and recent developments with respect to the relationship between the Convention and national legal orders. And the first speaker I want to introduce to you today is Professor Catherine van de Heyning. Catherine, are you there?
Yes, I'm there.
Welcome, Catherine. So Catherine is a professor of European fundamental rights at the University of Antwerp. Catherine did her doctorate at the University of Antwerp on the topic of multi-level protection of human rights in the European legal space. So she really is an expert in this domain. She co-edited a book on human rights protection in the European legal order, the interaction between the European and national courts, which is published with Intersensia. And in addition to working as an academic in Antwerp, Catherine is also a practicing lawyer specializing in cybercrime, cybersecurity, and criminal law. And Catherine will be talking about a very topical issue, procedural rationality in times of authoritarian regimes. Catherine, the floor is yours.
So thank you very much, Stephan. Thank you all for having me. So I will be introducing procedural rationality. And okay, this is okay. And I will also prepare a PowerPoint. I'm not sure whether you see it.
We can see the PowerPoint, but we don't see you.
Okay, share my webcam then. So now you should see my PowerPoint and you should see me.
Yes.
Okay, perfect. So I will be introducing a theme and some elements also for discussion. So rather than come to one conclusion, I rather hope that we can open the floor on this and have a discussion on this. So I will be focusing on procedural rationality, which for some might not be a surprise, given that several of us, and me including, have entered into the debate of the merits of procedural rationality. And the new element I want to add to that is to what extent this discussion is changing because of a unfortunate turn of several of the high contracting parties to authoritarianism and the backsliding of democracy and the rule of law in the Council of Europe. I really want to introduce this theme and start at a very basic level to ensure that really everyone's on board. Because the nice part of this conference is that the scope of discussion is really broad, and sometimes you enter in these really specialist seminars, which can be nice, of course, because you can really go into depth. But here, I really enjoy that the topics are of such a broad range. And congratulations also to the organizers on that part. So this is the basics where I think we're all on the same board, that the convention system was intended to be subsidiary. In the first place, it's to the national courts to guarantee the protection of fundamental rights. And of course, for those member states who have constitutional courts or who have constitutional adjudication, it will be constitutional rights and mostly interpreted in the light of the convention that will be enforced at the national level. And so the convention was meant to be a threshold. The common critique on the European Court of Human Rights system is that this minimum threshold has been pushed up and up and up to such an extent that was never envisaged by the founding fathers, and secondly, that it would overstep its boundaries, its competences, and leaving little or at least not sufficient space for national states to protect fundamental rights or to provide their approach to fundamental rights within a democratic and rule of law framework at the national level. And of course, there are some reasons that, or some elements that, or the reasons why it has this threshold has extended. Some are non-controversial, and that's the first one, of course, because of the individual complaint system, and that has become compulsory since the Protocol 11. You of course get more questions, and if you get more questions, you get more case law, and if you get more case law, of course, you will get more case law of the European Court of Human Rights, limiting or giving a different perspective on the minimum threshold. And I would say that is non-controversial because, of course, that is something with which the high contracting parties agree to when enacting the Protocol 11. So that is the non-controversial part. The controversial parts are in the first place, of course, the living instrument doctrine. And on the basis of this doctrine, the European Court of Human Rights has also developed case law, which was probably not envisaged or was not envisaged by the founding fathers, but by stating that the convention needs to be effective and practical, the convention needs to be interpreted in the current context. And so, of course, you will get as well more case law that can be a surprise to certain member states, and that will also push that threshold, because you're also creating more case law and lifting that threshold along with a better protection in a national member states. And the last part, and which is also controversial in some states and is completely non-controversial in other states, is national implementation. The national courts, both the ordinary courts as the constitutional courts or highest administrative courts, have started to interpret the case law of the European Court of Human Rights as inspirational, as a source of interpretation, but in some extent as quasi-binding. And that's also the reason why we now say that the convention is a quasi-constitutional document. And so national legislation, including national constitution, will be interpreted not just in the light of the convention, but also in the light of the case law of the European Court of Human Rights. And so where a judgment that in principle should not be so problematic for one state because the European Court of Human Rights had found another state to violate the convention, will be applied in all the different states, all the several states, because of course national courts start to interpret national law in the light of the convention and the case law. And in that respect, simply then being an extraordinary individual complaint system at the regional level, it has really become implemented in national states, and it's obviously also there that a lot of states find that the convention system has limited their scope, what they would say for democratic rule, and has gone too far. And so that's the discussion that is up, that's the critique on the European Court of Human Rights, that it has overstepped its boundaries and that the impact of that case law is far beyond what was envisaged by the founding fathers. And so that the subsidiary role is not safeguarded by the European Court of Human Rights. And one of the elements that is always the most problematic, of course, is not where you've got a core violation finding, but where you have balancing, where you have the balancing of two rights, two fundamental rights, or constitutional rights with a convention right, or where you have a balancing of rights and certain interests, legitimate interests, such as public security, of course, in this case, which is relevant today with a public health and in the COVID probation. And the court always balanced on the basis of the proportionality test, which is very well known by everyone probably following this seminar. And the proportionality test is not an easy one, and there's a lot of leeway. And to ensure its subsidiary role, as is well known by all of you, the court developed the margin of appreciation. And the margin of appreciation was the idea that if you have balancing and in the application of the proportionality test, under certain conditions, the state should be given some maneuvering space because they have a democratic legitimacy, or because in some cases that the area of policy on which the court is to decide is on economic or policy initiatives, and for that reason also more leeway should be given. Moral or ethical issues, you probably also know the criteria. But we know what the main critique is on the margin of appreciation, that it is applied in an incoherent way by the European Court of Human Rights. And that often comes also from people who believe that the European Court of Human Rights is not going far enough in protecting human rights. On the other hand, from some states who are thinking that the European Court of Human Rights is going too far, you get a critique that the court is biased, that it will provide a wide margin for, let's say, some countries and a narrow margin or no margin for other states. And that this is biased, and this is used as well in political speech. And the European Court of Human Rights has become a political tool almost that is being used by not so much by proponents of the courts, but rather by the opposition to tackle the court, to undermine the court, and to make or push the image of a court that is limiting democracy in the national states. And so the court has really been trying to make this margin of appreciation more coherent or more structural, or to have a better foreseeability of the margin of appreciation. And that is where you will get the critique. On this one is a famous critique, of course, of Lord Sumpton of the United Kingdom, that the court treats the margin as a matter of concession to the member states. It's the court who decides whether it's a wide or narrow margin, and on the ground that they are likely to know more about local conditions than the judges in Strasbourg. It should be for national states to have to decide on that margin. And so that is the critique that has been on the court for quite some time. And this is where procedural rationality enters. It is a manner to objectify or to have a more objective approach to your proportionality test. Why are you providing a wide or narrow margin? What are you taking into account? And to avoid that critique of bias, or that you would be selective as to what some member states and you would be negative towards other member states, a procedural approach seems more objectifiable or more objective. And so this implies that the court will take the quality of the decision-making procedure as a decisive factor for its assessment of the proportionality of a domestic measure. Or an alternative version of that, which I like as well, is that where the quality of debate at the national level is strong, then the court will embrace its subsidiary role at the fullest and approach the measure in question with a presumption of deference to be rebutted only by weighty consideration. So you will get a wide margin if the quality of the democratic debate is high, then you will get a wide margin, and you really need to touch upon the core, the essence of that human right for the presumption to be rebutted and for the European Court of Human Rights to step in. So where we will be looking at, and if you take a look at the case law of the European Court of Human Rights on this, where we will be looking at in the first place is, of course, a democratic debate within Parliament. So whether there was a debate, whether there was an impact assessment that was used, or other documents that were used, was there expert evidence that was used, was there also a debate, for example, in the commissions, were all different interests taken into account, was there afterwards, are there remedies, are there procedural remedies, is there a debate in the national courts? And of course there Supreme Courts and constitutional courts play an important role, because if there is a debate at a level at a constitutional court where all the different rights and interests are weighed one against the other, and you have already a reference either to the case law of the European Court of Human Rights explicitly or implicitly, where the same balancing is applied, then you could say, as the European Court of Human Rights, look, our subsidiary role now demands us that we take a different role, because there has been a procedural qualitative debate, and so then it's not for us to step in. So that's the framework of procedural rationality. And you can really see that in those cases, for example, on the blanket bans for a burqas, where the court, European Court, made a reference to the national debate that had taken several years, and that was marked by a wide debate in Parliament, and also that there was a thorough examination by the Constitutional Court, and that all interests had been involved. So the procedure is both the quality of the debate, you see also the length of the debate, the fact that there was discussion in Parliament, the democratic part of the discussion, but also at the Constitutional Court, the judicial and the remedies that are provided, that the court says here we're going to apply deference. The critique, and that is where we come at the authoritarian regimes, is that this is not without danger, because a procedural approach, of course, the question is to what you state it's procedural, and you might try to make it objective. But of course, you can design a procedure that looks very good from the outside, and where you take all the necessary steps, but because you make sure that every participant will act as you request as an authoritarian regime, because you undermine, for example, the independence of judges or of ombudsman or of experts, that it looks like a procedural rational process, but in fact that substantially that independent review that you're requiring is undermined. And I like to make reference to, I think, a very good point that was made by colleagues Kumper and Lewis, that states that the greater the emphasis placed on domestic procedure, the greater the incentive will be for states to show that they are conducting the right kind of debate, one in which human rights issues are properly considered and balanced against competing factors. But this will not help you if you are actually limiting, or you are encroaching upon minority rights, because you can have a perfectly you can have a debate in Parliament, but where minority rights are simply not taken seriously into consideration, and where the majority in the end will just push its voice. And if you don't have independence of your courts, of course, this will simply be mimicked at the level of a constitutional court. And one of the very recent and hot examples is, of course, the Polish constitutional case of last week on abortion, where the Polish Constitutional Tribunal's independence has been undermined for quite some months now. And you see in this case that the court is not simply saying, well, it is the opinion of the majority of the population that abortion should be outlawed, or that they make reference to the what the majority party is saying. That's not what they're doing. They are offering some kind of balancing where they say, well, we need to take into account constitutional rights, and there are also positive obligations on constitutional rights, and from the right of human dignity, they then develop a right to life for a fetus from the start. And so you see that they are taking constitutional language basically to push through a political point, a policy point that the ruling party is advocating for quite some time. And so procedural rationality has this danger that it becomes a Trojan horse for authoritarian regimes. There are two approaches to avoid this. And the first you can see in the Konstantin Markin case against Russia from the court of quite some time ago, where the Constitutional Court went substantive in its procedural review, saying that that the Constitutional Court in Russia had gone too easily with the legislature's assumption, but that it did not check the statistical data or did not weigh the conflicting interests. The Constitutional Court has simply said, well, the Parliament has done its task. It has used objective elements such as data, but the Constitutional Court did not check it themselves. And so the manner in which a watchdog role is approached as a Constitutional Court is taken under review by the European Court of Human Rights. And only if that watchdog role is fulfilled, a procedural rationality would be appropriate. A second approach is what was proposed by colleague Olivier de Schutter, which is some kind of Bosphorus-like presumption, which means that if there is an equivalent protection, that only when there is an equivalent protection of independence of judiciary and availability of remedies that are that ensure a fair trial in an independent court, only in that case procedural rationality would be appropriate, and that would undermine, of course, this Trojan horse approach of certain member states. I will finish up because probably I've been talking already too long, but just to show how difficult today it is to make sure that on the one hand you have a coherent approach to the proportionality test and to avoid this part of being the reproach of being biased towards some member states, but on the other hand to avoid that member states that have an authoritarian turn, that they would not abuse procedural rationality, or the legitimate critique of some member states on the court, and abuse that simply to push a undemocratic, a negative approach to human rights. Just to make sure, or just to show how difficult it is, I put up the quote from the Heyning case against Hungary of 2008. And where you show how fast it can go and how fast a constitutional court even can switch from a watchdog role, or a democracy can switch from a strong democracy into a problematic democracy. Only in 2008, this was the quote from the European Court of Human Rights, that Hungary has a stable democracy, that it has an integration of the value system of the Council, and that there is no evidence at all to suggest that there is a real and present danger of any political movement or party restoring communist dictatorship. So you see how fast this can change. And if constitutional courts are to be safeguards and that this would warrant a margin to the court, obviously we need to watch the independence of these courts.
Thank you, Catherine, for this thought-provoking presentation. Procedural rationality is, of course, a topical issue, not only with respect to authoritarian regimes, but also with respect to COVID measures and the use or misuse of procedural rationality to justify or not to justify reviewing or not reviewing COVID measures. Will become a topic of discussion in a time to come. Before we move on to the next speaker, Willem Verrijd, I want to discuss some practical issues. I would suggest that we keep the questions for after the 3 presentations, but I'm happy to already start collecting your questions. So if you have a question, don't wait until after the 3 presentations. Please put your questions in the chat box so I can start collecting them. And we can pose, and I will pose the questions after the 3 presentations. Also, I want to make sure that we finish on time, so there's no need to escape to the kitchen. You will have sufficient time for your lunch break. I will keep a close look at my watch. The next speaker I'm very happy to introduce is Willem Verrijd. Willem is a lecturer at the KU Leuven Law Faculty, but he's also a law clerk at the Belgian Constitutional Court, and he clerked to the former president of that court, André Ahle. And in that capacity, Willem has had a unique insight in how the Belgian Constitutional Court, but also other constitutional courts in Europe, see their relationship, their position, their relationship with the European Court of Human Rights. And Willem will be talking about the dialogue between the European Court of Human Rights and those domestic constitutional courts. Willem, the floor is yours.
Thank you, Stephan. Is my PowerPoint presentation visible?
Yes.
Okay, thank you. I have written a contribution together with Professor and former President of the Constitutional Court, André Ahle, in the Liber Amicorum Parlements, and my current presentation will be based on it. It is also set against the same background as Catherine's presentation, the virus which is currently spreading and is called the dismantling of the rule of law across the world and even in Europe. Authoritarian regimes try to downsize the independence of the judiciary. And I believe that against such a background, it is imperative that national and supranational judges work together as allies instead of fighting each other and thus further undermining the resilience of the entire human rights system. Yet the literature on the relation between the European courts and the highest national courts does use 2 distinct narratives. One of both is the narrative of wartime terminology. The other one uses more collegiate terminology, such as constitutional pluralism, Verfassungsgerichtsverbund, and judicial dialogue. Although both narratives describe the same reality of coexistence of human rights catalogues and their respective courts, it seems to me that the choice of the narrative is not a neutral one in times when the rule of law is already under pressure. I have a strong preference for the second narrative, and the aim of the current presentation is to show that the relation between the Belgian Constitutional Court and the European Court of Human Rights indeed better reflects the narrative of constitutional pluralism and judicial dialogue. Now, this paper in the Liber Amicorum Parliaments counted about 50 pages, so I will not be able to delve into every detail and every example described in it, and I will have to limit myself to providing some general information on the relationship between both courts. Several legal scholars have applied Habermas's prerequisites for a successful dialogue to the relation between national constitutional courts and both European courts. The first prerequisite already shows that the context of constitutional pluralism does not exclude differences of opinion. On the contrary, differing viewpoints are the necessary fuel for any dialogue. What matters is that such discussions are the exception and in an otherwise harmonious relationship. In the relation between the Constitutional Court and the European Court of Human Rights, these 6 prerequisites are all met, but I will only focus on 3 of them. The first remark involves the common ground of understanding. Do constitutional courts speak the same language as the Strasbourg Court if they can only review legislation against the national constitution and not against the convention? My answer is yes, because both courts share the same historical, philosophical, and societal background. But concerning the Belgian Constitutional Court, even more can be said. The Constitutional Court has overcome this so-called language hurdle by developing 2 techniques allowing it to apply international law in its constitutional review. The first technique is based on the principle of equality, enshrined in the Articles 10 and 11 of the Constitution. According to the Constitutional Court, these provisions have a general scope forbidding all discriminations, regardless their origins. Therefore, the court may examine whether the legislator has created a distinction between categories of persons in the enjoyment of rights conferred by any other source of law, including international and European law and the Convention. The second technique is called the analogy doctrine. Most constitutional rights have a counterpart in international and European human rights conventions. And according to the Constitutional Court, these convention and constitutional-based rights form an inextricable unity, which the court must take into account when interpreting the Constitution. When the Constitutional Court applies these techniques, it doesn't only use the text of the Convention, but also the European Court's case law interpreting them. It uses the Strasbourg interpretation of a convention right as a minimum standard, without lowering the sometimes more protecting constitutional standards. Because of this, we can conclude that the Constitutional Court effectively speaks the language of the Strasbourg Court, giving both courts a common ground of understanding, enabling a true dialogue. The second remark relates to the prerequisite that none of both courts has complete authority over the other. It is true that the Strasbourg Court may condemn Belgium because of an insufficiently protective judgment by the Constitutional Court, but let's not forget that it has no jurisdiction to quash the Constitutional Court's judgments, and it will always need the domestic judges' cooperation for the day-to-day implementation of its case law. The third remark relates to the prerequisite of equal opportunity to participate. A direct dialogue between the Strasbourg Court and the Belgian Constitutional Court is not possible because Belgium has yet to ratify the 16th protocol, but other possibilities of an indirect dialogue do exist. Supreme national courts may simply voice criticism in their own judgments, hoping that it will be picked up by the Strasbourg Court. and the Lautsi and Alkawaya cases do show that such an endeavor may be successful, but it nevertheless comes with a double risk. First, the Strasbourg court might never notice the critical judgment. And second, if it disagrees, it might have to condemn Belgium. The first risk is mitigated by the creation of the Superior Courts Network, which was set up by the Strasbourg Courts initiative in order to facilitate the exchange of information with currently 93 highest courts of 40 member states. The second risk might be overcome if the Constitutional Court on the one hand criticizes the Strasbourg Court's solution, but on the other hand applies it correctly. The Constitutional Court has some experience with this technique in the field of EU law by stressing its disagreement with the ECJ's answer to a preliminary reference, but nevertheless simply applying the answer after all. Now let's take a look at both parties in the dialogue. The Belgian Constitutional Court is a very active participant because it mentions the convention in about a third of all of its judgments, and it cites or even quotes the ECTHR's case law in a quarter of its judgments. Taking into account that the convention is not among its formal reference provisions, this is a quite significant amount. In addition to this, the Constitutional Court also applies EU law and the ECJ's jurisprudence to another significant set of cases. The Constitutional Court doesn't merely mention the Strasbourg Court's case law, but it also applies the legal concepts developed by the Strasbourg Court, such as the margin of appreciation, the autonomous interpretation, positive obligations, and so on. Interestingly, it also uses all the procedural techniques it has in order to take into account the minimum standards set by the Strasbourg Court. If it is aware of a relevant case pending before the court, it sometimes awaits that case's outcome before adjudicating a similar case. We did so with the Hurst case. The Hurst case against the UK was pending before the Grand Chamber. We had a similar case awaiting our adjudication. We simply awaited until the Grand Chamber had finished and then adjudicated the similar Belgian case. Also, the court has already reopened the hearings in pending cases, which were already under deliberation, in order to allow the parties to argue about new developments in the Strasbourg Court's case law. It also has sent a couple of cases to the ECJ if it was of the opinion that the directive it had to apply breached the minimum standards set by the Strasbourg Court. So to sum up, the Constitutional Court goes at great lengths to accommodate the European Court's case law. And while most of the scholars do applaud that approach, two types of criticism are nevertheless voiced in the Belgian legal doctrine. On the one hand, some authors do criticize the fact that the court applies supranational factual judgments despite significant differences to its abstract review of legislation in a sometimes completely different type of cases. On the other hand, authors sometimes criticize the court's blind compliance with supranational case law, whereas the latter is itself subject to doctrinal criticism. As I said in the introduction, the Constitutional Court's approach is not a monologue. The European Court, in turn, does pick up the Constitutional Court's case law and does respond to it. In a vast majority of cases against Belgium, in which the Constitutional Court has had a prior involvement, the Strasbourg Court agrees with the Constitutional Court's findings and does not condemn Belgium. The exceptions, I have mentioned them, only 4 cases, are very rare, and in these cases, the Constitutional Court has always immediately adapted its own case law and started mentioning and applying the condemning judgments. The Strasbourg Court also picks up Constitutional Court's case law in cases against other countries. For example, the Michaud case about the professional secrecy of lawyers. The Constitutional Court had already ruled that an EU directive should not oblige a lawyer to disclose information he receives in his relationship of confidentiality with his client. And in the Michaud case, the European Court took a very similar position, explicitly referring to that Constitutional Court judgment. I have one suggestion to make in this account. It would further facilitate the dialogue between the Belgian Constitutional Court and the European Court of Human Rights if the latter would apply a stricter approach to the exhaustion of domestic remedies. Currently, it does not require that the procedure before the Constitutional Court would be exhausted in cases where an alleged violation of human rights is linked to formal legislation. But nevertheless, the court should, according to me, require the exhaustion of a direct action for annulment if the petitioner should have known that he would become a victim during the 6 months delay for filing the action for annulment. It should also require that the parties would, at least before the national judge, suggest that he would refer the case for a preliminary reference to the Constitutional Court before turning to the Strasbourg Court. I conclude by listing the many benefits of the Constitutional Court's approach. First of all, this approach benefits the Constitutional Court itself, allowing it to modernize the constitutional rights catalog in the Constitution, which is for a large part outdated, uses old-fashioned concepts, and thus expand the ambit of its own constitutional review. Also, it seems that the reticence of many other constitutional courts to make explicit use of supranational texts and jurisprudence might be driven by a fear of diminishing the legitimacy of their own constitutional review. I believe that the opposite is true. Interpreting the Constitution alongside more modern supranational documents rather adds to the legitimacy of the entire rule of law construction and also to the legitimacy of the Constitutional Court, which shows that it is prepared to take into account the reality of constitutional pluralism. Moreover, by systematically applying EU law and the Convention and systematically mentioning the case law of both European courts, the Constitutional Court might be able to build up the necessary trust and credit with these courts that it can use in the rare occasions in which it has to become critical. The European Court of Human Rights, I believe, also benefits from the Constitutional Court's approach because it helps reducing the criticism that the European Court is always interfering with the national political decisions. If the same criticism is voiced by national courts using the same arguments, I believe that this dilutes this type of criticism. Most importantly, I believe that the entire legal order can benefit from the Constitutional Court's approach. First, because it reduces the risk that Belgium would be condemned by the European Court for violating the Convention. It is always better to set a violation straight in the internal order without the international visibility of a condemnation by the Strasbourg. And second, and most importantly, the Constitutional Court's approach considerably reduces the risk of diverging interpretations of human rights. And this fosters legal certainty and strengthens the legitimacy of human rights review as a whole. In a context in which the rule of law is under siege, that benefit is, according to me, of crucial importance. That's it. If you might have any questions, please feel free to ask them now or send them by email. Thank you very much.
Thank you very much, Willem, for sketching the perspective of the Belgian Constitutional Court and other constitutional jurisdictions. And I repeat Willem's question. So if you have questions, please send them via the chat box. Allow me to introduce the final speaker in this second panel, Professor Janneke Gerards. Welcome, Janneke. Janneke Gerards is Professor of Fundamental Rights Law at the University of Utrecht in the Netherlands, and she's of course well known for her work on the relationship between the European Convention on Human Rights, domestic legal orders, and the EU legal order. Janneke is also, as most of you know, the author of a brilliant handbook on the Convention entitled The General Principles of the European Convention of Human Rights, which is published with Cambridge University. And Janneke will be talking about the two-stage method of adjudicating convention rights, and she will be looking at how that two-stage model allows for diversity. Janneke, the floor is yours.
Okay, thank you very much for this very kind introduction, and it really is a great pleasure to be able to celebrate the Convention's 70th anniversary today. And I'm very happy that the University of Leuven has been able to organize this event. And I also like to be part of this great panel. I think we've already heard two very interesting, very important perspectives on this relationship that we are discussing in this panel on between the European Court and the national legal orders. And indeed, to those perspectives, I would like to add some of my own, which I have presented earlier in the celebratory book for Paul Lemons, who we will also hear later today. And the observations that I would like to share, they relate to the common knowledge about the way the court relates to national legal orders. And that I think ought to be nuanced a little when we actually take a closer look at what the court is actually doing in its case law. So to explain that, I think it's perhaps necessary to first clarify what this common knowledge is. And in fact, I think it finds its basis in this eternal struggle between the court's need, on the one hand, to strive for uniformity, and on the other hand, the need to respect national diversity. So put very briefly, on the one hand, fundamental rights, of course, are claimed to be universal. And if anything, of course, that means that it shouldn't matter for their validity, for their meaning, whether they are claimed in Armenia or in Belgium or in Iceland or in Russia. So from that perspective, the convention rights should be uniformly guaranteed in all the convention states. So the expectation could be that ECHR rights are uniformly defined and delineated in the court's case law to ensure that the convention rights actually mean the same thing in all the European states. But on the other hand, and it has been emphasized already today, we all know that the convention system is famous for its development of the principle of subsidiarity, with the doctrine of the margin of appreciation being its most significant manifestation. And to the extent that these notions mean that the European Court of Human Rights should show deference to the way convention rights are protected on the national level, this clearly means that it will not be easy to ensure fully uniform protection of human rights. Indeed, this struggle means that different national traditions and legal rules might lead to different levels of protection. And the European Court of Human Rights might be inclined to respect those differences in the levels of protection. And in fact, this struggle and the existence of it, I think that's the common knowledge. And in fact, I fully accept that it exists. But I think there's more to this, because there is another aspect to this common knowledge, and that is related to the difference between the two separate stages involved in deciding on fundamental rights cases. So on the one hand, there is the determination of the scope of rights, so the interpretation of the terms and notions contained in the Convention. On the other hand, we have their application to an individual case, or in many cases, the stage of justification. So then we're talking about deciding, for instance, on the necessity and reasonableness of certain interferences with the Convention rights. Well, in the light of this notion of universality, and in the light of the court's interpretative function, it is mostly thought that the court mainly strives to offer uniformity through its definition of the various terms and notions of the Convention. Indeed, this seems to be the rationale behind autonomous interpretation. So the court has always emphasized that notions such as family life or tribunal, they ought to have the same meaning for all the states. And for that reason, it tends to give a typical convention interpretation to these notions. And once it has been uniformly established what a convention right means, in the stage of application and justification, national circumstances might start playing a role. And indeed, it is at this stage of justification that this margin of appreciation doctrine may come in, and that national considerations regarding necessity and proportionality may cause differences in outcome between otherwise seemingly similar cases. So this is what we assume that happens. We think that the tension between the need for uniformity of human rights protection and the need to respect national diversity is solved by providing rather abstract and general but uniform interpretation of the convention rights, which can then be applied in a more concrete fashion to the individual case, taking account of particular national conditions. But let's take a closer look at the case law, because I don't think that this commonly accepted explanation is fully correct. So first, what we can see is that the need for uniformity actually plays a much smaller role in the stage of interpretation than is commonly assumed. For one thing, the court hardly ever expressly refers to notions of uniformity or legal unity as an argument for choosing an autonomous interpretation. It may refer to the need to avoid at stages dodge convention protection, or in rare cases, it refers to the need for equal protection of individuals. But legal unity certainly is not an objective per se for it. But more important than the rhetoric of uniformity is what the court is actually doing. And looking closely, I think we can see quite some exceptions to the rule that the court's determination of scope is uniform. And the most famous of that is, of course, the Vaux case, an older case in which the court left it to the states to decide when the right to life actually begins. So if it begins at birth, or at conception, or somewhere in between. And the court has taken a similar approach in a few other cases. For instance, in relation to the applicability of the right to a fair trial, to the right to freedom of religion. But I admit these examples are few and far in between. But what does occur much more often is that the court applies what I've termed an in for a penny, in for a pound approach. And that approach entails that the court doesn't provide for a uniform and autonomous interpretation of a convention provision, but it actually connects the applicability of convention provisions to the national recognition of a certain individual right. And we saw an example of this just the other week in a case against Armenia. In that case, the applicant had claimed that he had the right to be compensated for the damage he had suffered because he had been imprisoned after a conviction, but then the conviction had been set aside by a court of appeal for procedural reasons. And actually, it's well established of the case law of the court that Article 5, paragraph 5 doesn't apply to that kind of situation, since it is the court's position that a period of detention based on a lawful judgment is actually not an unlawful detention. So Based on that, and taking a uniform level of protection, the court could have left it at that, and it could find the case to be inadmissible on that basis. But in fact, the court continued to reason that on the national level, it was accepted that in the situation in hand, the detention was unlawful, and that for that reason, a certain right to compensation arose. So to say, the Armenian system was in for a penny. But then the court held it should also be in for the pound granted by the convention system. If this particular definition is given to the right to liberty on the national level, and implicitly on the national level, Article 5 has been accepted to apply, the national authority should be willing to accept that all the court's case law on the meaning of Article 5, paragraph 5 also applies. So in line with the court's case law, the national courts should not have restricted itself to paying monetary compensation for the unlawful detention, but should, in line with the court's case law, also have compensated the applicant for the immaterial damage that he had suffered. Well, you can probably imagine that this particular approach may lead to different levels of protection in different states. As long as a state does not guarantee a certain right, the court may consider that a certain issue falls outside the scope of the convention, and it may not be able to impose any particular obligations on the state. But as soon as the state has taken measures that somehow can be connected to convention rights, the court will seize on that and require the state to act in full compliance with the convention. Well, to my mind, that means that there is little truth to this first part of the common knowledge that interpretation requires uniformity, and diversity plays a role only in the stage of application. In most cases, uniformity or equality are not expressly mentioned as a ground for adopting autonomous interpretations, and there are many cases in which the court decides to refrain from taking a uniform approach, but relies on the national diverse standards of protection instead. So what then about this second stage? Surely it must be true that respect for national legal orders and national diversity plays an important role in nearly all the cases where the court gets to the stage of assessment of a justification. Well, I think it's not. Or at least, I think we can see many situations in which the court actually does manage to effectuate some uniformity in a stage of application. And I have not much time left, but let me just briefly list some examples for you here. So first, I think we can see that the court has defined rather concrete, precise, and uniform tests in relation to cases that concern core aspects of convention rights. So you can think here of the obligation to respect peaceful protests, the fairness of criminal procedure, or the dissolution of political parties. And in such cases, there is very little leeway for the states to advance a justification. The court's review is very strict, and in fact, national particularities or preferences hardly matter at all. And that results in imposing rather uniform standards in these cases that states simply have to abide by. And in turn, that might contribute to a degree of harmonization of national human rights law in these types of cases. Second, some degree of convergence is stimulated by the court's increasing demand that national courts apply the general standards and principles it has defined for such cases, using a bit of a carrot and stick approach. So if the national courts have properly used the court standards, they may be commended for that, and the court will not easily find a violation. But if a national court has, for instance, in a defamation case, refrained from adequately balancing different rights and interests in line with the court standards, the court may easily find a violation. So this is a type of procedural review, but it's of a slightly different nature than the ones that have been discussed by Catherine van der Heyning in her presentation. This really is about courts being incentivized to implement the court's general principles in national decision-making, and indirectly, that could lead to a gradual convergence of standards of human rights on the national level. And third, it is striking that the court may often leave a margin of appreciation in cases on the justification of interferences, and also in cases about substantive positive obligations, but it hardly ever does so insofar as procedural positive obligations are concerned. And the court has set procedural obligations in a great many cases, so ranging from cases on child protection and family law to disputes on electoral rights. And in fact, these procedural obligations, they can be very detailed. And to my knowledge, the court shows little deference here to national particularities that could justify that a particular procedural obligation has not been met. So here too, the court imposes relatively uniform standards. So I think that these examples show that some degree of uniformity can actually be achieved by the courts in the stage of application or justification, even though it's commonly thought to be the stage where diversity might matter the most. So to conclude, I think this shows that the court does far from always strive for uniformity in interpretation and for respect for diversity in assessing a justification. In fact, it can be the other way around. And perhaps that's surprising to some, since it's not in accordance with what we think we know about the court's case law. But then again, it is very much in line with the court's overall highly pragmatic approach towards dealing with this struggle between uniformity and diversity. In fact, the court generally tends to avoid very strong doctrines and dogmas, and simply seems to find as many ways as possible to get the states to offer this high and fair level of protection. And indeed, although I'm sure that the compromises the court strikes may be unsatisfactory at times, I think it's quite amazing what it has been able to achieve over the 70 years of existence of the Convention, using this very pragmatic approach. And that actually is what I wanted to share with you today. And I'll stop here then. But of course, I'm very curious to learn your thoughts and questions about this. And for now, I just would like to thank you for listening and for your attention.
Thank you very much, Janneke, for your very interesting presentation that challenges conventional wisdom. I see we have one question so far, a question by Janneke, by the way. There's still time to pose your questions. If that's okay for the members of the panel, I want to kick off with two questions. Perhaps my first question is a question for Janneke. Janneke, the European Court of Human Rights is famous for its open-ended, very context-sensitive approach at the second stage of the inquiry, the proportionality test. My question is, you've studied the case law, also recent developments. Do you see an increase in a more categorical decision-making method, or you see the court using more definitional balancing as a method, formulating concrete standards, rules to be applied in future cases, which would lead to more uniformity and predictability as well. So do you see such an evolution? And then secondly, do you think that that would be a welcome evolution? Do you welcome this, taking into account, of course, that European Court of Human Rights is a supranational court, not a domestic constitutional court? Do you think that such a more categorical approach is a welcome evolution of the European Court of Human Rights?
Thank you very much for those really good questions. I think indeed this is a development that we can see in the case law of the European Court. So over time, and of course it's also in the natural course of things in a way. I mean, if you just start as an international court, or as a national court for that matter, you don't have much to go on. But over time, when you've been deciding numerous cases on similar topics, you will have to be consistent, and you will have to find some general principles that well, have been invoked in a particular case, and that should be equally invoked in similar cases. Otherwise, you would probably be inconsistent in your case law. So I think that's a natural way of reasoning judgment to use reasoning by analogy in a way. And this can easily build into these more general standards and principles that the court has developed over time. I think it also has made that more into some kind of strategy, in that especially the Grand Chamber is, I mean, it's a messy kind of development. So in individual cases, these general principles are usually applied more or less, but they are also always a little bit tweaked and a little bit changed in order to adapt them to the specific situation that we have in hand in a particular case. So they are developing for that reason, and because of the fact that, well, cases make bad law, and they might grow inconsistent, and the court might be taking a direction that it actually dislikes itself. Once every time the Grand Chamber takes up a case and might bring things together and create a new consistent line of case law in which it actually defines these overall general principles. And that we can very clearly see. The thing is that these general principles are not always as strict as you could suppose them to be. So sometimes they are. So in the cases that the examples that I mentioned, for instance, in cases about demonstrations or some kind of criminal procedure kind of cases, the court had set very detailed and very precise general standards that well, more or less must be adopted on the national level. But in other cases, which are much more controversial, these general principles are still relatively loosely, undeterminedly defined, and there's many possibilities for national courts and national legislative bodies to give shape to them. And there probably the court also finds the leeway it actually needs to negotiate in this relation of tension that it has with the member states. So on the one hand, I think this is a good development because it's giving clarity. It's giving clarity to applicants. It's giving clarity to national bodies. They know what to expect. They know what standards the European Court of Human Rights will be using, and that might, well, increase this level of protection that Catherine also has been discussing. But still, because of the fact that these are standards rather than rules, and they might not always be as precise and detailed as in some cases more than in others. There is still a lot of possibility and a lot of liberty for the courts to say, well, yes, in this particular case, with this particular set of facts, we will still allow for justification, even though in the previous case maybe the same set of standards has had a different outcome. So on the one hand, it's creating some kind of legal certainty, and at the same time, I think it's still leaving a lot of scope to the states, and I think that's well, I'm a big fan of that kind of pragmatic decision making by courts, but I know that there's a lot of people who disagree with me on that. Okay, thank you. So my second question is for Catherine. Concerns procedural rationality. My question concerns the scope and limits of procedural rationality as a decision-making method, a method allowing a degree of deference to domestic decision makers. We know that the proportionality test consists of a number of rather factual, empirical questions. Suitability, are the means suitable to achieve the stated aim? Necessity, are the less restrictive alternatives? But that there are also a number of purely normative, moral aspects, the balancing of competing rights and interests, the proportionality in the strict sense. To what extent do you think that procedural rationality is useful to review the way in which those moral questions were tackled at the domestic level? And we can use the Polish abortion case as an example. In the end, that case boils down to the domestic constitutional balancing between the right of the unborn child against the autonomy of women. And this is a purely moral question, not a factual, empirical question. To what extent is procedural rationality useful to review those types of moral, domestic, constitutional, and democratic decisions?
Well, I think that the first, I see two questions, or two steps rather. Like the first question is, whether, before we talk about procedural rationality, whether the margin of appreciation is appropriate here at all, and to what extent. And we've always agreed, or that comes from the case law, of course, that in these kind of fundamental ethical and moral issues and how it's balanced in a specific state, that a rather wide margin in principle is provided. And their procedural rationality could be an element to, and there I really think that it's a question that Janneke asked as well. I think procedural rationality can improve also the debate. Of course, my focus here was rather on the dangers of a specific approach to procedural rationality, but procedural rationality can also improve the debate, because you are asking of a parliament, you're asking of government, you're asking also of constitutional courts to substantiate their balancing process. And also, and one of the elements can also be to take into account the case law of the European Court of Human Rights and the quality of that. And Leonie Habes wrote an excellent book with Intersentia on this, because Janneke is not only excellent on her own behalf, but also as a supervisor. And so I really think this is a very good work of her. So in that perspective, I think procedural rationality could add here as well. But the main issue, of course, here with the Constitutional Court's decision in the abortion case is that you can take that case face value. You can take that judgment face value and say a balance has been struck. I think that this case in itself, face value, would even not pass the scrutiny if certain interests were not taken into account. The rights of women were actually not taken into account. The right to life, or the human treatment of women was not taken into account, and also some other rights that are concerned were simply not considered. So I would say the balancing was in any case not developed sufficiently. But from a procedural rationality, and that's really the point that I would be making, the question is, are we going to engage with the Polish Constitutional Court in Strasbourg in this way, by stating, okay, we have here a deliberation of the Constitutional Court of Poland, and there are good arguments on both sides. Procedural rationality, imagine that it's, mentioned also the other arguments and set aside. Are we going to engage in the future in this way with a Constitutional Court of which we know that there are extreme problems with independence of this court? Are we going to decide that procedural rationality in itself is still legitimate and can be applied to findings of certain courts, which in other cases we might find that the judicial judicial independence is violated? So, and that is not just a question of the European Court of Human Rights, it's also for me a question for the European Court of Justice. We are discussing with several of these courts, or still on a basis as if we are having a normal, or the dialogue, so to speak, while on the other hand we're having procedures against member states because they undermine the dependence of these courts. And I'm posing the question. I don't yet have the answer whether we should stay on this dialogue approach, where in this case we'd say, well, anyway, procedural rationality, you did not have actually, you have not taken into account all the interests. Or alternatively, are we also going to stop doing that discussion in that respect and saying, and that's Olivier de Schutter's approach, well, the presumption that you have an equivalent protection with all due respect has been rebutted, and so there is a narrow margin. And then still, of course, you can come to the conclusion that a fair balance was struck, but you have a narrow margin, and procedural rationality in that case is no longer appropriate. So I think that's really the discussion, unfortunately, where we are at this moment. And when we started talking about procedural rationality, we were discussing issues like like the constitutional critique from the Netherlands or the United Kingdom or Switzerland, where there were also genuine remarks which were debatable. But now, of course, when you see it disguise a tool where a constitutional court is used to give a authoritarian regime some leeway, then I think I'm not sure, and I'm tending to be negative to just apply this procedural approach.
Okay, thank you, Catherine. So we have 2 questions and we have 10 minutes left. The first question is a question of Janneke. Janneke, perhaps it's you can just pose the question yourself. Oh, I can read it, but it's
actually in her really great reply to your question. Catherine has also answered my question, which was actually about, well, the fact that procedural rationality review can have very different forms. So it can be a replacement substitute for proportionality review, but also can be well, one factor in determining the scope of the margin of appreciation, or it could be used in the way that I described it. So rather as a way of trying to find out whether national courts have properly balanced all the interests involved, and it's really depending on the way in which the court is using it, whether it's a legitimate kind of method and whether it actually had some use for the court. But I think Catherine has just stated that just brilliantly. So my question is fully answered now.
all right. So then there's a question from Helga Molbach-Steensing. Thank you for your question, Helga. Let me just read out the question. It's a question for Catherine on the definition of the good debate. What do you see in the case law in terms of differentiating between participation in a debate by different actors? You mentioned very reasonably that while the democratic debate on a topic certainly creates some legitimacy, it can also be problematic when the persons whose rights are interfered with are minorities. Some European jurisdictions do not have a tradition for judicial constitutional review. How should this play into the court's determination of whether there has been a good debate and procedure at the national level?
I think in the best of traditions, of course, it are those well, independent voices that are included. So that would be, as I mentioned, experts coming to Parliament and talk, or expert advice, impact assessment, but also simply looking at the debate that has been held in Parliament, whether and to what extent also minority voices were heard, and whether there is a protection of minorities. Because of course, and that is the issue as well, because I mentioned the burqa cases. One of the critiques you can also have on those cases is that the court states, well, there was an overwhelming majority. And it was very clear that this was discussed, and at the end of the discussion, everyone was basically, or the vast majority was still on the same line. And the Constitutional Court as well mentioned that, well, everything was taken on board. And so definitely in those cases, and I think those are the most dangerous, difficult ones, is where you have an extreme majority in Parliament, but where some minority rights can be definitely limited into an extent that is that would touch, and that is of course the substantial part that remains upon the core of a constitutional right. So procedural rationality is not or a discussion with substantial review, because there will always be that element of substantial review that remains, which is the core of fundamental rights and the threshold function of the European Convention. But the good debate can, of course, depends from country to country, and constitutional review can be an element, but is not required. And definitely for me, what is also probably one of the most important elements to take into account is whether you have procedural remedies as well. So in that respect, that a decision is made that would limit the rights of certain minorities in a manner incompatible with the convention, that there are procedural, independent, of course, remedies at the national state. And so there, I really think that in a context, it is not just a parliament or the courts. They both are in the trias politica. They are both are a part of the solution on procedural rationality. But I think that where we are very confident with courts, we are less looking often to the, and I think that's a point also made by Leonie, which I really like, is the quality of legislation and how you make legislation. And of course, in the case of the European Court of Human Rights, you have a lot of criteria on that as well, and how to include minority voices. But where I would definitely follow is that it is more difficult to discern where you are talking about big minorities, and also, and that's topical now, of course, where you have a certain emergency situation, which was in terrorist cases and is now the case with COVID, where you will have some where there is a leeway for government, but where expert advice and expertise and inclusion might be some of those most important elements for the quality of the debate, or to define what's the quality of the debate.
Okay, thank you, Catherine.
Have an approach to that.
I see there are no other questions. Oh, there's another. Is there another question? Yes. My question is on the procedural review on core rights discussed by Janneke and Catherine. Their procedural review could be viewed as a positive development in the sense that member states which are very loyal towards the European Court, such as Belgium, secure human rights protection. But how about the less court-abiding member states? Does the procedural approach of the court not undermine the substantive human rights protection? A question by Baya Aras. Thank you very much. 4 more minutes, so
Janneke.
Well, that's a really difficult question, actually. I think it again depends very much on what type of procedural review you are choosing. Of course, if you use it as a substitute for the actual balancing review, it doesn't really help these states forward. But if you use it in the carrot and stick approach manner that I've been describing, it could make some sense. So usually courts on the national level feel much happier if their judgments are actually not somehow found to be incompatible with the convention by the European Court of Human Rights. So they might strive to at least take the court standard seriously in their case law if the court actually says, well, this is a really good effort on the national level. So when we are reading judgments, I think we often think that the court is actually trying to be some kind of a teacher also to national courts, and I think that in a way could be helpful on the national level. Of course, it doesn't solve problems at the really. So this is something that, as I've heard of national judges also, that is especially taken to heart by lower courts. On this higher level, so for instance, well, perhaps Belgium is not a good example, being a really well, obedient court, so to say. But courts, highest court, constitutional courts in countries like Poland and Hungary and Russia and some others, they will probably not be tempted by this particular approach. So they're probably the only way will be to actually find a real hardcore violation of the convention. I think that's what we can actually see the court doing. So there are not that many examples of cases where a national constitutional or high court in one of these problematic states well, has given a very bad kind of judgment, and then the court would be taking a procedural approach. I think that you can't often see that. So yeah, whether that would be more effective in actually bringing those cases to those countries to act better in compliance with the convention, I don't know. I think there's many more factors involved in that. But so procedural review anyway, I think plays only this minor role. But perhaps Catherine has a different view on that.
I fully follow. So, so Stephan, I'm helping you with saying that I agree on most of the points of Janneke on this, and I repeat what I mentioned before, but maybe from a historical perspective, of course, that several of those countries where we find it difficult how we're going to approach this. Referring back to that quote I mentioned from Vanyan, that most of those were on the path, of course, of integration and were using those procedures in a genuine way or a developing way, and then have taken a turn. And so they were familiar with how the judicial dialogue works and how the margin of appreciation can function, and is now I feel like they are a little bit being hijacked. So there's definitely a challenge there for the court for the coming 10 years, and I very much hope not for the coming 70 years.
Okay, that's a nice note to conclude. So allow me first to thank the participants. Most of you are still attending. Let me also thank, of course, the three panelists, Willem, Janneke, and Catherine, for their interesting presentation. By the way, Catherine, Wisconsin is still too close to vote, but Biden is still leading there. Perhaps a practical announcement before we conclude. This session will end now, and we will start a new session at 1 p.m. So at 1 p.m. after the lunch break, we will hear the keynote speech of Professor and Judge Paul Lennes. Thank you for participating today, for being here, and I hope to see you after the lunch break. Thank you.
Thank you.